Hello, it's Attorney Mike Graveline coming to you from Chicago as usual, and we're picking back up with Mr. Lau. Last install. This is number 4. I don't know how long it's going to last. I haven't seen it. In the last episode, he was saying that he was going to move his cars and rent a space. I don't believe that that's going to happen, but we'll find out. Oh, they were worried. This is in December, and I remember that from the last hearing. They were, Mr. Lau was afraid of bumping into the erection. November 8th. Let's do this thing. Let's see what craziness we have. Oh, I forgot about that. He was. That was so weird.
Please rise. The Municipal Court for the City of Boulder is now in session. The Honorable Judge Jeff Kahn is presiding.
You can be seated. Thank you. Thank you. And we are on the record. Let's go ahead and call the parking matters that we have scheduled for trial for Michael Lau. I'm going to take a quick look at where we're at here.
Yeah, he's like
Greg, when we scheduled this, did we indicate exactly which tickets
the
were
two
going
girls,
to trial?
one fez defendant. Only one shirt for
I
court.
see 4 tickets that in the case, Your Honor. I wasn't.
That's what I thought we were doing, was 4 tickets. So it's the 4 that are at the bottom here. All right, let me go over these and make sure everybody's on the same page. We've got 4 different citations that were issued. And what we discussed with Mr. Lau is that perhaps we'll have the trial on these 4 tickets today, and then we'll see what the outcome of that is and determine whether there's going to be other cases that he wants to set for trial. I don't know if there are, but right now there are 4 citations that were issued that are scheduled for trial. And Mr. Lau, are you concerned about that? Do you understand what we were talking about?
Yes, Your Honor. But of course, due to the afternoon snow day and so forth, we were not able to convene in court earlier. My apology on that. I was circling the parking lot when I talked to Greg on the phone, looking for a place to park. So earlier, I have sent in a motion this morning, both for adding additional tickets and for continuance. I've explained why, but in summary, Your Honor,
he's got more tickets, of course.
I have requested that the court adds the additional tickets because I got some 30 plus tickets and warnings and so forth. Shortly after this case was set. And I've asked on the 29th for the court. I did not hear back. I emailed Mr. Reynolds on November 4th, asking that he adds those additional cases so we don't have to keep doing this exercise each and every week. And he said he is unable to unless instructed by the court. So there were other little deficiency in my perspective from the discovery information that Mr. Reynolds sent to me, but that's from my perspective. But in summary, in short, Your Honor, I do not wish to be a frequent visitor here each and every week based on the additional tickets that I keep getting every week. And I receive additional ones just this week on Monday. So
this guy.
And of course, that would definitely meet the 15. And apparently they've changed it to 14, which I fail to understand why. But anyway, so Your Honor,
I'll tell you why, because you keep parking in the wrong place. oh my God, he's here to tell on the police or whatever, the parking authority, for issuing more tickets to him. It's unbelievable.
If we just try to do the 4, it actually will likely be the same. PMO will be, of course, the same prosecutor and so forth on the each and every one. And Your Honor, you stated much earlier that I do have the rights to ask for a trial on each of these tickets. I am just trying to avoid the need to be here each and every week going over the same similar issues. Thank you, Your Honor.
All right, so you're entitled to a trial on those that you
breaking
request
law.
a trial within the
A-hole.
timeline that's set by city ordinance, which is 14 days from the date that the ticket's issued. If you request a trial on those, you'll be entitled to a trial. When you were here previously, we agreed that I would, although you'd requested a trial in a lot of cases, that I would set the trial for 4 cases on the same day. The court does have the authority to schedule trials. And I didn't schedule 20 trials for this afternoon because we can't get 20 trials done in an afternoon. Each one is a different incident and maybe with the same officer, but with different facts. And so to have 4 trials is actually a bit of a challenge to put them all on one docket. We're going to do that today because it's an efficient way to do it, but we're not going to do all 20. Nor are we going to try to schedule them every day, one trial at a time. We will try to accommodate both parties' needs for efficiency. But this one was scheduled with the idea that we'll have this first trial on these first 4 tickets. We'll have a separate trial on each one today. I'll determine an outcome on those. And then if you desire to set other cases for trial, if you have the legal right to have a trial on those, then we'll schedule those for trial. I haven't addressed those yet. I'm just addressing these 4 today. And the fact that you get new tickets is not up to me. If parking services or the police department issues citations and you decide to set them for trial, then you have the right to set them for trial as long as you request a trial within the 14 days. And Mr. Reynolds was correct. He does not have the authority to set cases for trial, to add tickets to trial. That's up to the court to decide. We manage the docket for trials.
Thank you, Your Honor. I understand.
In fairness, I don't know. I have not seen
when this case was created. Of course, I was in court that day. I believe it was Monday, but within 1 or 2 days subsequent to that, I believe the following day, I got somewhere give or take 10 tickets. And I was here in court on that Wednesday. And of course, I showed those tickets that I have already just received to you. And I believe, Your Honor, you've also quickly looked and that you also, I guess, realized that I did receive some tickets right away. So
I'm not going to
have already brought it up at that point.
I'm not deciding which ones you have a right to trial on. I understand you may have an argument that you asked for trial on all of those.
Yes.
We don't need to litigate. We'll figure that out from here as to which ones you've made a request for trial for in a timely way. Okay. The fact that you may have raised those issues and wanting a trial on all those back on that date, if that was timely made, then I'll acknowledge that. Okay. But right now I want to just focus on the 4 tickets that are scheduled for trial for today. Does that make sense?
Yes, Your Honor.
And I don't want to continue these over because we've already continued once. And I think it's in everybody's interest to get a resolution of these first 4 tickets, and then we can talk later about scheduling others. Mr. Reynolds, did you have any comments to make before we get started?
Your Honor, I do just want to point out that in the motion that Mr. Lau filed this morning, this afternoon, that he alleged is saying that also saying that we did not provide sufficient discovery on the bottom of the motion.
I do see that. And what are you saying about the discovery? I'm not sure what you mean about that, Mr. Lau. So if you want to articulate further, what is it that you're asking Mr. Reynolds to provide?
When the lead PMO was testifying on behalf of the, of course, plaintiff, I believe that was the Monday. He clearly stated that the voter parking receive a complaint, whether it's call in, phone in, or whatever. I've been trying to get a transcript of that. However, I have not been able to yet. So the process starts when there is a formal complaint made, and with the T2 information that Mr. Reynolds has already emailed me on the 4 tickets, I only discovered that there is a public comment portion, but there was no entry of any information. So whether the fact that they were properly in the lead PMO testimony, whether there was a actual complaint made, and then the parking office then follow up and pursue that, or whether it was just some truly unexplainable reason why they would decide to just come to my specific area and target and issue me 10 plus tickets without looking at any of the illegally parked, too close to curb, too far from curb, too close to whatever the 4 or 5 foot, whatever those things are called, too close to crosswalk because I live across from a school. I am not saying in this case that maybe the officer should be running around ticketing everybody. I am just saying I need to see why this officer was even down in my area ticketing my vehicle only, and whether the complaint was, oh, there's some guy across the street that has obviously multiple illegally parked or registered or whatever. I believe, based on the testimony and based on policy and procedure, there is some accountability to state that, and I haven't seen that. So it's whether it's my figment of imagination of not seeing it or misimagine, or the PMO total disregard for due process and just decide to come down and ticket me and me only. I'm not sure if that, well, because it's part of their policy and procedure, and because it's part of their discovery, in my opinion, I need to know. And of course, otherwise there's no way for me to defend myself other than responding to poor photos that's printed out. But Mr. Reynolds has emailed me other ones that has much higher quality.
Okay. Mr. Reynolds, you want to respond to that?
You can't disregard
Your Honor,
photo.
My understanding of the request is that Mr. Lau
Cute little
wants
puppy.
to know like the names of people who might have called parking services to make complaints about parking issues in and around that area. And the city does not believe that would be proper discovery because it's not relevant to the matter as to whether or not these vehicles had current registration. And we are concerned if we provide information that is with their specific names that there potentially could be some sort of creation of other issues on at 290 Pawnee, that neighborhood, in terms of we don't think it would happen, but it potentially could open people up to some sort of retaliation. And just because it has such extremely, well, I don't think it has any relevance or has very, very, very limited relevance, we are just going to provide him with who has called to complain about illegal parking on the street because we think it could create larger issues and it's just simply not relevant to what we're talking about here.
Objection, Your Honor. While I agree, I do agree with not providing the prosecutor is more than welcome to redact certain specific name information, but not even making any attempt to document that based on the testimony of the lead PMO in court that is the official procedure. I am left with oh, okay. For the sake of, it's not even privacy issue, because they actually make whoever it may be, email, telephone, or whatever, the call. While I do sympathize with Mr. Reynolds' position, but redacting the name would at least allow me to see when that was made and by what means. And I already asked Mr. Reynolds, once again, that general information on November 4th. Your Honor.
I agree with Mr. Reynolds. It's the information that you're seeking is not relevant evidence. It's not likely to lead to the admissibility of relevant evidence. The evidence that is going to be of interest to the court in deciding whether your vehicle was parked unlawfully will be the evidence that is provided by the prosecution in connection with that vehicle. Whether someone called or not called to report it, if that person is not a person who's going to be called to testify by the prosecution and is not subject to their case, I don't believe that person is going to be, there's any purpose in me ordering the discovery or disclosure of those individuals. And so I'm going to deny the motion for discovery. I'm denying the motion to continue as well, just to make the record clear. And so let's get started with the trial. I want to outline the 4 cases so that we're clear. So I'm going to pull up the 4 tickets that were entered into our full court system. And I'm going to start with the one that ends in 3987. There are 4 tickets. The one that ends in 3987 is one from October 11th of 2024, alleged to have occurred at 11:18 a.m. And the comment on that one is that the trailer was parked over 48 hours on a city street, and that's the alleged violation under the violation code of the camper, RV, or trailer parking prohibited ordinance. And Mr. Reynolds, can you tell me the subsection for that, just so I have it for that?
Yes, Your Honor, 7624B.
Okay, so that's the subsection for that one.
B is in boy.
Thank you.
7624B. This allegedly occurred at 4600 block of Sioux Drive on October 11th of 2024. And that's the ticket that ends in 3987. So I'm going to outline each of these. And then what I want from a presentation perspective, Mr. Reynolds, is we'll do them one after the other. Otherwise, I think it might get confusing. So we'll just have a trial on case number 3987, and then we'll go to the next one. That way, nobody gets confused. We talk simply about one at a time. It may be very short trials. It may be long. I don't know, but we'll do it that way rather than having testimony about this ticket and then this ticket and this ticket and cross-examination. In the court's perspective, we should treat it the same way as we would with a traffic case. And given the history for these cases, I think it's going to be cleaner if we keep each one. And so you'll call the officer. The officer will be subject to cross-examination. You can do redirect. Mr. Lau can testify about that ticket, and then I'll do an order on that one, and then we'll go to the next one.
The question I have for the court, and is it okay if I'm seated right now, Your Honor?
Absolutely,
Is,
perfectly fine.
in terms of our exhibit numbering, I've already numbered my exhibits, and I have them 1 through 7.
Yes.
So, and obviously the exhibits pertain to different tickets. So like if we did 3987, the one the court just spoke about, my exhibits for that one are exhibits 4 and 5. And so I wouldn't be numbering, otherwise we'd have to have like exhibit 1 for each of them, and then we'd have a bunch of exhibit 1s. So I would keep them separate. And so for that one, I would probably keep the numbering system. I'd have 2 exhibits, but they'd be exhibits 4 and 5.
I think that's perfectly appropriate. Okay. We didn't have probably enough time when we were scheduling this to think it through as to how we would handle exhibits, but I think that's probably the best way, is to leave them in the system, because it's one full court case that we've got here with 4 different parking citations.
And then it's going to be the same officer for all 4 tickets, and I might lay some background for that officer on one of them. And then if Mr. Lau is okay with it, I might just ask the court to take notice of his background information from that one ticket instead of him explaining his job for each one.
And if you'll just do that in the subsequent trials, that would make sense. Okay, let's start with that case number 3987. Then I've outlined what that case is about, what that charge is about. Do we want to do opening statements on this, Mr. Reynolds? Did you want to give an opening statement?
Your Honor, I just very, very briefly, I'll say my opening statement is that this ticket pertains to a violation of a trailer that is allegedly parked longer than 48 hours in violation of 7-6-24 B as in boy on October the 11th, 2024 at 11:18 a.m. And that's my opening statement.
All right, thank you. Mr. Lau, would you like to give an opening statement? You're not required to. You'll have the opportunity to testify if you choose to.
I'm fine with Mr. Reynolds' suggestion that the PMO does not have to repeat his background and so forth. And actually, I'd be happy for the sake of time for PMO just to address each ticket specifically right away instead of having to talk about a resume type of thing.
And that's fine. And if you'll waive those foundational requirements, we can, in the second trial, we can do it that way. So it sounds like we have an agreement on that.
Thank you.
All right, so let's go ahead and call your officer.
We'll just stand over here and the judge will swear it in.
And sir, if you'll state your full name and spell your last name for the record as a starting point.
My name is Sean Croto. My last name is Croteau.
And Officer Croto, if you'll raise your right hand for me. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Go ahead and have a seat. Whenever you're ready, Mr.
Thank
Reynolds.
you. Thank you, Your Honor. Good afternoon, Officer Croto. Officer Croto, where do you work?
I work for City of Boulder Community Vitality Parking and Access.
And what is your job title?
My job title is Community Vitality Ambassador.
And what do you do as a Community Vitality Ambassador?
I do a couple of different things. Setting up special events, coordinating that with road closures, and also writing parking tickets within the City of Boulder.
And how long have you done this job for?
For almost 5 years now.
And are you familiar with the address of 290 Pawnee in the City of Boulder, state of Colorado?
Yes.
And how is it that you're familiar with that address?
I respond to call complaints over in that area, and that's how I know of that area.
All complaints pertaining to?
Parking violations.
And were you on duty working on October the 11th of this year, 2024, at about 11 in the morning?
Yes.
Did you find yourself in the area of 290 Pawnee at that time on that day?
Yes.
And what were you doing there?
We were over there to check on some complaints that we had that were put into a queue because we had been told to kind of hold off and grant Mr. Lau some time to go ahead and clear some items off of his area that he lives at. So we held off and we were holding complaints to serve until that moment.
And on October the 11th of this year, on that day, if you had to put a number on it, how many times had you been to that area of that address to address parking situations?
I would say anywhere between 20 to 30, approximately up to 30.
So were you pretty familiar with the vehicles that were there?
Yes.
I'm going to approach with what's been marked as people's exhibits 4 and 5. Copies of these have been furnished to Mr. Lau. Officer Croto, can you just take a look at these?
Yes.
Do you recognize those photographs that I just handed you?
Yes.
How is it that you recognize them?
These appear to be the photos from one of my citations that I gave that day.
Okay. And did you end up issuing some citations that day?
I did, yes.
Do you remember the types of citations you issued that day?
Yes. As I recall, the citations that I was writing that day were going to be valid plate and camper RV trailer citations.
And exhibits 4 and 5, do they appear to be fair and accurate representation of the scene as it appeared on October the 11th that day?
Correct.
I'd move to admit people's exhibits 4 and 5.
Any objection to the admission
No
of
objection.
extra exhibits? Okay, exhibits 4 and 5 will be admitted.
And I just want to note for the court as well that these exhibits have been uploaded to the to full court, and so they're labeled the same way. So if the court wanted to view them while we were talking, that is a way to do that.
I'm actually doing that. Thank you for that. I appreciate it.
So in exhibit 4, Officer Croto, what are we looking at here?
It's gonna be a picture of one of the trailers that I had cited that day.
And is there any sort of a law on the books for the city of Boulder about how long a trailer such as this can be parked on a public street?
Yes, there is. It's permitted to park there for 48 hours or less in front of the registered owner's home. And 72 hours can be granted if it's providing a service to that residency or business. That would be the only caveat.
And on this day, on October the 11th, 2024, at about 11 in the morning, did you have information to lead you to believe that the trailer had been parked there longer than 48 hours?
I don't recall.
Maybe I'll ask it a different way. Was that trailer parked there longer than 48 hours?
When I had first began the watch on this vehicle, it was July of 26 is when the warning was issued. Per the checkup on August 2nd, it received its first valid citation. And in section C of 7-6-24, it does state that a camper motorhome trailer has to be removed off of the city streets to be in compliance with this section. So this is just kind of further on down.
And so the trailer, is it accurate that the license plate is Colorado DNPZ37?
Correct.
And so you mentioned that you had first seen that trailer parked there in July of this year?
Correct, yeah.
And at that time was a warning issued?
Correct. The first few times I got calls to this location, I did just give warnings in good faith that the parking would be corrected.
And was it warnings for having the vehicle on the street longer than 48 hours?
Correct, yes.
And then you mentioned that there was an actual ticket issued?
Eventually, we had to start getting real tickets for it, and it started on August 2nd.
Okay. And the ticket that we're talking about today was issued on October 11th of 2024?
Correct, yes.
So it sounds like that trailer had been parked there for at least 3 months.
Approximately, yes.
Objection, Your Honor.
What's the objection?
The prosecutor just assumed, and of course is trying to convey the witness to testify that the trailer has never been moved, used for other purpose other than being parked there stationary, left there stationary for 3+ months. Unless Boulder Parking prior to issuing the over 48 hour or whatever based on 760.
What you're trying to say is assumes facts, not in evidence. That's it. You only do the legal basis. You don't do these speaking objections. But if the judge is going to let him,
For whatever, unless there is photo proof, whether by the photo camera on his vehicle or that he took specifically, or he chopped the tires and so forth, just because they are in the same general vicinity in the prosecutor's word, over 3 months does not mean they actually were there specifically 48 hours prior to the ticket being issued.
Okay, so I get the gesture of what you're saying.
Thank you.
Suggesting. I'm going to overrule the objection. You're going to be free to argue that, and you can also ask questions of the officer and testify yourself to whether the vehicle was moved within the 48-hour period. The testimony that I've heard so far is the officer believes it was in the same position. Is that accurate, officer?
So yeah, per my observation, yes, but pertaining to the citation, it doesn't matter. The citation was issued.
Let's just stick with
Okay.
that one fact is I want to make sure that the testimony is clear. So is it your testimony, officer, that you did not see that the
Everybody
vehicle was
does
in a different place than from somewhere before?
Yeah, I don't have any.
Is
proof
the
of
water
that,
out there?
no, as it doesn't pertain to the citation.
Okay, and I'll let Mr. Reynolds address those issues going forward. But make sure you just answer his questions. I know if I were in your shoes, I would want to share every piece of information that was in my head about a case. But really, you have to just answer his questions. And then when Mr. Lau asks questions, answer his questions.
Yeah, no problem.
Thank you, Officer Croteau.
Thank you for sharing.
So
Now
over
share
the
live.
course of at least since July of this year, when you visited, that vehicle was parked on the street every time you were there, correct?
Affirmative, yes,
And it was on the street in the vicinity of 290 Pawnee.
yes.
So do you have a photographic memory of all of the different vehicles that you encounter over the course of months of your work?
No,
And would it be practical as a parking enforcement officer to record all of the vehicles that you contact for any reason as part of your job all day long?
He's an
no, the
ambassador
only
counselor.
record would be citations.
Or, do you keep a record of warnings too?
It would be in the back office of the TQ,
Um,
but I wouldn't have that offhand, off memory, no.
And People's Exhibit number 5 that I have there, is that the license plate of the trailer?
Yes,
And who does this trailer belong to?
Mr. Lau.
I don't have any other questions for Officer Croteau on this ticket, Your Honor.
Okay, Mr. Lau, it's your opportunity now to ask questions of the officer. So you're allowed to ask questions of him. And then if there's other questions for Mr. Reynolds, he'll ask those in a moment. You can stay seated or you can stand at the lectern, whatever's more comfortable for you.
If I may be remain seated. Mr. Officer, so yes, we have past previous encounters at that in the vicinity of that location. So you drive one of the newer vehicles. Does it not have plate scanning or anything like that?
Yes, it
So if you drove by it, and of course, I know you circled the area enough that you're very familiar with the area. Does the system on board of your vehicle automatically tracks that information?
So yes, if it's turned on and it's activated, it would, correct, yes.
And do you usually don't turn it on, or do you usually turn it on?
So yeah, we usually use that device when we're enforcing permitted areas. So unfortunately, 290 Pawnee is not in the permitted area, so it usually isn't on when I drive by.
Okay.
Sometimes it is on randomly, but not always.
So then your observation over the past 3 months, as the prosecutor tried to have you remember, is that you see that vehicle definitely in that general vicinity. But of course, and you said you don't need, and nobody expect you to have photographic memory. You don't recall whether it is because of the space thing, and there are actually two trailers, one practically touching each other. And there is only so much room because of the school crosswalk and all that stuff. So, and I'm sure you may have some recollection that there are at times additional stuff on it, and there are on the specific trailer that we're referring to, and at times there are specific things that are not on that specific trailer again. And it's not the same item all the time. It's just so. Can you vouch to the court that I've never moved it over this, whether it's 3 months or 48-hour period prior to this specific ticket that you issued, that is the case? Can you?
So yeah, so as it pertains to the camper RV trailer ticket, How that works is we give it a warning.
Objection,
48
compound and
hours,
stupid.
we'll check on it to see if that vehicle has moved out of the area. Typically, we'll check it on that third day, depending on
Where is the warning?
Oh, it would be on the citation, that would be put on the vehicle.
You,
It was on the September 26th was the last date that trailer had received a warning. I mean, going forward, it was real citations because it was.
sorry,
still there.
so, but 3987, as we're still referring to, does not have the warning information, does it?
It does, yeah. So there was multiple warnings written to this trailer out of good faith in July.
I don't have a copy of the ticket here. Do you actually have a copy?
Oh, I
Does the
looked
system look?
at the vehicle history before I came in here for citations. So that was, the last warning was written on July 26, 2024. And then the checkup that preceded that to give the first citation for this offense was going to be on August 2nd. And then going forward, per section C of 7-6-24, to be in compliance with this section, the vehicle must be removed off the street.
Forever.
That's what it says, yeah.
Actually, we actually have two face-to-face
Yeah.
discussion about that. And I thank you for providing me the printout of that.
Yeah, yeah.
Where, okay, now, because you specifically told me that your supervisor,
Ask a
Leo
question.
Pellet, actually challenged you and asked you, where does it say that it can remain on the street after this period of time? So it must be off city street, period. Do you recall that discussion?
I do recall that discussion.
Okay, so where specifically that was his interpretation of sections of C, and which you relay to me.
Yeah.
And but where is that? Where is that specifically in section C that specify that?
It's going to be the second sentence in section C states that. And the reason why we had that conversation was because I was going with good faith when we first started interacting, hoping that we were going to get compliance. And unfortunately, the complaints kept coming in, and I was directed to go ahead and follow it to the letter until we had some kind of compliance in that area.
And a little bit before that time, of course, you're also aware that I have of course, made an attempt to contact Ali, but of course, he did not respond to me. But I also, actually, thanks to you, officer, I actually got the email address of the city manager because you helped me track that.
These are kind of testimony type questions, right?
No, Your
So
Honor.
this is saying you can't say things that you've done or talk about what you've done. You can ask him questions only. If you decide to testify, you can testify.
Thank you.
So
Thank
this
you, Your Honor.
objection sustained.
Mr. Officer, do you recall you provide the city manager's email address to me?
So I had looked it up for you because
Yes.
I did want to help you.
Yes.
Because I did
And I thank
understand that you were in a jam with
Yeah.
code compliance and code enforcement. And
Thank
we were
you.
all getting entwined over there. So I did want to try to, in good faith, try to help you the best I could.
Thank you. And I appreciate that very much. And I was able to email, once again.
Just questions.
Yes. So this time period that you've ticketed me is past the city manager overnight parking permit. That's correct?
Correct, yes.
And so other than and once again, you testified section C, number 2, simply state that, but it's you testified,
Let me stop you for
Sorry.
a moment. I'm just going to read what subsection C says because I don't want to have,
please.
it's not the officer's job or the
No, I
witness.
don't have it in front of me, but
So
I.
let me read it.
on
It says it
previous
shall not
occasions.
be of defense to this section that the camper, motorhome, or trailer has been moved to a different location on any street. To be in compliance with this section, the vehicle must be removed from the street. That's what 7624C says. And let me just point out to the parties, it's really not up to anybody in the courtroom other than me in this particular circumstance to make a determination of what the ordinance says or what it means. All the officer has to do is testify to the facts of what the officer observed and why he wrote the ticket. Whether it's Mr. Pelly's interpretation or the officer's interpretation, what really matters is up to the court. So questions to the officer are sort of irrelevant to me, because it ultimately is up to me to decide how the ordinance applies. So keep your questions to him about facts and not about what Leo Pelly thinks the ordinance says or what the officer thinks the ordinance says. It's just what the ordinance says and then my interpretation of it. So ask questions about the vehicle, the trailer, how long it was there. That's what's relevant to the court. That's all that's relevant to me, is whether it violated the 48-hour rule.
Thank you, Your Honor. So
Thank you for what?
you have, other than the section that you testified to, and a certain interpretation of that, which kind of prompted you, because we truly had that discussion previously. Prior to this specific ticket being issued, that you don't have photo or any physical record that showing that it was in the exact same spot unmoved for a period of 48 hours. And so I'm not asking you to try to interpret the section C or whatever, because it's inappropriate for me to even. So yeah, so my question is that, do you have any photo proof that it was there for the 48 or longer period prior to that 3987 ticket being issued?
No, I don't, as it doesn't pertain to the citation.
Thank you.
There could be evidence as far as abandonment, because usually these two things follow in line as far as an abandonment and 48 hours.
Oh my
there could
God.
be evidence that we have for that.
This guy needs to shut up.
I just prepped for the camper RV ordinance today for these tickets specifically.
Everyone's
Let's not
talking
go into
about-
any cases that weren't filed. Let's stick to the actual charge. The charge here is that you violated 7624, and that is, and subsection B is that you had a vehicle parked on a street for 48 consecutive hours. And that's the allegation, is that it was on for a consecutive period of 48 hours. The vehicle was on a single family or in front of the single family or multi-family dwelling, and it was parked there for 48 consecutive hours. Abandonment is not an issue in this trial. The only abandonment is not an issue in this trial. The only thing at issue in this trial is that subsection. So let's keep it to that for everybody.
So thank you. Honor, you threw me off slightly off my thought pattern a little bit. So once again, Ms. Officer, you do not have physical record that during a 48-hour period prior to the ticket being issued, that specific trailer was in that specific spot at all. You do not have any photo, nor written or monitored evidence as you sit here in court trying to remember the situation.
So there could be evidence that we have with the abandonment that was tied to that vehicle.
Officer, I'm going to ask you to answer the question. The question was, do you have evidence, either photo evidence or from your own memory, that the vehicle was moved in that 48 hours? Just answer that question.
I'm not sure.
I am satisfied with the officer's answer.
Okay. Any other questions for the officer? No, I'm talking to you, Mr. Lau. Any questions from you?
Oh, no.
You're done asking? You're done?
I'm sorry. I said I'm already satisfied with the officer's answer.
And you don't have any other questions? Okay.
Yes.
Mr. Reynolds, any other legal?
Very briefly, Your Honor. Officer Croto, license plate Colorado DNP Z37 belonging to this trailer. Did you see it parked on the street at that location in July?
Correct, yes.
Did you see it there in August?
I did,
Did you
yes.
see it there in September?
I did, yes.
And how do you know that you saw it there in those months?
Because call complaints came in, I went to serve them, and when I started vehicles up, either as abandoned or on the camper RV trailer watch, all that stuff was documented in our abandoned and out log.
Thank you. No further questions.
All right, thank you. Officer, you can step down. So the city has presented their evidence on this particular ticket, and now it's your opportunity. If you choose to, you can testify. You're not required to. Mr. Lau, the evidence I have right now comes from the officer. The only evidence I consider in the trial is what the officer testified to so far and those 2 exhibits that have been admitted. If you want to testify, you have the opportunity to do that. You can't be forced to testify, so it's up to you to decide that.
If I may just testify briefly.
All right, why don't you come on forward? I'll swear you in.
Oh, okay, thank you.
And if you'll raise your right hand for me. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, go ahead and have a seat.
Thank you.
And remember, we're just on case number 3987 from the October 11th date, the allegation being 7624B, no camper, motorhome, or trailer shall be parked on any street except as follows, which is for when located directly on a street frontage of the single family or multifamily dwelling of the vehicle's registered owner for a consecutive period of 48 hours or less. That's the issue for the court.
Thank you, Your Honor. So this specific trailer, of course, has been there for an extended duration because it's to facilitate the code enforcement complaint, the case that, of course, Your Honor, of course, is also in charge of. So there has been, this trailer is a little bit smaller and more mobile
it's your
than
fault.
the bigger gooseneck trailer that's in the back. So it's been used on many occasions, moving things away from the property at 290 Pawnee Drives.
And that's why it's all still there.
The
That's
fact
why you're
that
still getting tickets.
there is a certain interpretation by the supervisor of parking that it is once you exceeded the 24 hours or whatever, that it becomes a forever ban on City of Boulder Street. That to me is not apparent to me, a layperson, based on reading not only that specific line
We don't care if it's apparent to you
C or B
at all.
at all. In fact, when it was passed by, I believe, Mayor Susan, that.
I'm going to object. This is legal argument. It's not testimony.
Sustained. So here, let me tell you, you're going to get a chance to argue the interpretation of the ordinance during closing argument.
Oh, thank you.
So you will get that opportunity. For right now, you can only testify about the facts of the
So-
case. And then if you
Thank
want
Your
to
Honor.
make an argument about how I should interpret the ordinance,
Thank you.
both you and Mr. Reynolds are going to get that opportunity.
Thank you. Your Honor.
It's also
Once
standing
again,
objection. That's fine.
apology to the court
It's fine.
and to everybody who's here. That trailer has been used numerous times, both around the area, actually and at certain times to evade the officers coming around to issue parking tickets, but also to load things to move away. And actually is to move away not only to the North Boulder in the county storage that I've shared the information with Your Honor much earlier. It's also used to move things away from the property, whether it's to, auction houses, whether it's to giveaway, whether it's to certain dumpster situation. So while it has
Dumpster
appeared
situation.
there in that location over several months, it never stayed there untouched, unmoved over several months. And specifically, I challenged the notion that it was prior to this ticket being issued, because at that point, I was already receiving a myriad of tickets from the officer. So by then I have wise enough that I either need to move it, use it, or something like that. So I have been doing that. So the fact that there is no photo evidence showing that it was there prior for at least 48 hours prior to the ticket being issued, I challenge that. Of course, the citation was illegally written up. Thank you, Your Honor.
You're welcome. Any other testimony?
We're just on this one, right?
That's right.
No,
Just on this
that's
case.
it.
Mr. Reynolds, cross-examination.
I don't have any cross-examination, Your Honor.
Hang on just a second, Mr. Lau, because I may have a question.
Please.
You said I challenged that. Are you offering any testimony as to where the vehicle was from that period of 48 hours prior to October 11th? Do you have any information to provide the court on that?
What are you
And if not,
doing,
that's okay. I
Judge?
just want to make sure that it's clear.
He
Your Honor,
testified.
I do not have that because I was already overwhelmed with the multiple, not on just this trailer, but on multiple vehicles and that I'm receiving from the same officer. But it's actually, it is possible that I can obtain.
No, it would have to be right now because we're at trial.
Likewise, I won't be. I don't have immediate access to the school
Judge,
district
you're not his
security
attorney.
camera that actually points at this trailer. I also am at a loss, just like the officer, of saying I do not have that photo evidence at this moment, Your Honor.
Okay.
So I do not.
All right. Thank you. And any other questions based on my question, Mr. Reynolds?
No, Your Honor.
All right. You can step down, Mr. Lau.
Thank you.
Any rebuttal case from the people?
No, Your Honor.
Let's have closing arguments.
Thank you, Your Honor. So the people believe that they've proved beyond a reasonable doubt that this ordinance was violated. It's just simply no defense that the trailer perhaps was moved.
Reasonable doubt isn't the
subsection C of
standard,
the
but okay.
ordinance. It says that it's not a defense to this charge. The vehicle was moved to any street. It has to be removed from the street entirely. And Officer Croteau testified that he observed this trailer parked on the street for many months prior to actually issuing this citation in October, and had actually previously issued similar citations that for the same offense. And so that just indicates that this vehicle was present, and whether or not Mr. Lau was actually using it to move things around is just not a defense to the charge. And the people submit that they've proved beyond a reasonable doubt that this trailer was parked there much, much longer than 48 hours, which is prohibited by the ordinance.
All right, ring him up. Next.
And Mr. Lau, closing argument.
Oh.
Specifically, this trailer, once again, I can challenge the wording of this section, right?
You can argue with
Okay, thank
how you think it should be interpreted.
So I definitely challenge the wording of that. And the wording leading the supervisor, both the supervisor parking and actually Mr. Reynolds himself, to believe that the cannot be on city street wherever is the case. That's number one. Because when Mayor Susan passed that, I read the whole thing when it was signed, there was absolutely no reference or that in any context. Secondly, the T2 system on this trailer, for this specific trailer, would have actually also shown that this trailer was issued a parking ticket sitting in the side yard of this location. So I do not have that recollection off the top of my head, but it is a T2 thing. Whether that was some tickets were canceled, not at any of my requests, by any of my input, just so happened to be canceled. So this trailer was actually for a certain period on and off on the side yard of the street. So it was not on city street. So, but of course, while this ticket was issued, Your Honor, yes, it is on city street, but once again, there is no proof that it has remained on city street forever. And in fact, based on the T2 system Boulder Parking has, it would show that there were parking tickets issued for this trailer sitting on a private property, 290 Pawnee, on the side yard. So, Your Honor, that is my closing on this ticket.
Okay. So let me issue my findings on case number 3987. And I'll very briefly highlight what the issue is and then articulate the findings. And I am going to do a written order. It won't be today, but at some point I'll do a written order so that it's very clear how I interpret these ordinances. Section 7624 states, and it's called the all-night parking of commercial vehicle, camper, or motorhome or trailer prohibited ordinance. Under section 7624B, it states no camper, motorhome, or trailer shall be parked on any street. So it can't be parked on any street except as follows. And under B2, it says, B1, when located directly on a street frontage of the single family or multifamily dwelling of the vehicle's registered owner for a consecutive period of 48 hours or less. And then subsection C, which has been discussed here a little bit, says it shall not be a defense to this section that the camper, motorhome, or trailer has been moved to a different location on any street. To be in compliance with this section, the vehicle must be removed from the street. So as you read this ordinance, from an intention perspective, what it appears from the clear reading of the ordinance itself is the intention of the city council that adopted this ordinance was to prohibit trailers from parking on a street unless there are very specific exceptions that apply. And so this is under an exception of the basic prohibition that you can't park a trailer on a city street. And it says, well, if it's under subsections B1, a trailer can be parked on a city street for 48 hours or less if it's the registered owner's vehicle and it's parked on the street frontage of that single family or multi-family dwelling of that registered owner's residence. In this case, the evidence that I have from Officer Proto was that the trailer that's at issue here, which is depicted in Exhibits 4 and Exhibit 5. So no question that this was a trailer. No question that this trailer was registered to the defendant. Mr. Lau did not contest that. The evidence from Officer Croto was that he had seen this vehicle on July 26th, that this trailer was parked there. He issued a warning on August 2nd. He actually issued a citation, and then he saw the vehicle again, I believe he said September 26th, and that it was still in that same location, parked in front of that house. The only evidence that I have is that, again, then on October 11th, Officer Croto was there, and that vehicle was still there. An inference could be made from the court. A logical inference would be that that vehicle, which was parked there in July, that was parked there again in August, and that was parked there again in September, and then on October 11th, had been there continuous for that entire period. And so that's the inference that, although it wasn't requested by the city attorney that I make, that's the inference that I could logically make. Mr. Lau testified that he uses that vehicle numerous times to move things from the property. What he did not testify to, and what I did not hear even when I prompted him, was that the vehicle was moved somewhere off of a city street within the 48 hours preceding October 11th. There was no testimony to that effect, and nothing that the court has heard would lead the court to believe that the vehicle was moved from the 48 hours, which would basically be from October 9th to October 11th to some other location, which was not a city street. It would have to be moved onto private property or outside the city, but it can't simply be moved and then parked on another street or even in that street. Within that 48-hour period, the vehicle, if it's been in that period on there for 48 hours, then it's a violation. I would have preferred to have testimony from the Parking Services Division that they came out and actually saw the vehicle there for the 48 hours before, which would have been October 9th at 11 a.m., and that it was still on the city street on October 11th at 11 a.m. I didn't have that information, but I have decided that I'm going to make that logical inference that it was not moved to any private location, particularly because I didn't have any testimony to suggest that it was moved to a private location. The fact that it may have been used during that period and then brought back to that area, that doesn't mean that it was moved, and that breaks that 48-hour period from starting. And that may be what is being argued by Mr. Lau, but he didn't specifically make that argument. But the suggestion would be, if it's there and then I get in the vehicle and I move it around the block and then I park it there again, since it wasn't in that specific location, that it somehow can be there for another 48-hour period without an ordinance. That may apply in the abandoned vehicle provision. It does not apply here. It's very clear that when a vehicle is on a city street for 48 consecutive hours, that it violates the ordinance. Even if someone gets out and drives it for 5 or 10 minutes, or drives it to a junkyard and takes something else there and then brings it back, you can't park a vehicle, a trailer, on a city street for 48 consecutive hours. And in this case, I'm finding that it was parked for 48 consecutive hours because I don't have any evidence to the contrary. So I am going to find the defendant guilty of a violation of section 3987. All right, let's turn to the next case, which I'll just go back to our citations. And so this one, I'm going to move from the bottom up of the one, the ticket. So this will be case number ending in 3980. And I'm pulling up this citation. This was issued on October 11th, that same date at 10:36 a.m. So earlier than the other one. This is a temporary license plate expired provision under section 7623 of the Boulder Revised Code. And this also allegedly occurred at 4660 Sioux Drive. So are the parties ready to proceed on that second ordinance?
Yes, yes.
Second ticket. Are you ready?
Sir, may I have that number again?
Yes.
Last 4 digits?
The last 4 digits are, just pulled it up, but I can't see it again. 3980.
Thank you, Young.
So we'll proceed on that one. And again, that's from October 11th, that same date that we were talking about earlier. This is a valid license plate or registration charge under section 7623 of the Boulder Revised Code. Let me pull up 7623.
And Your Honor, Mr. Lau, the city would be proceeding that it was a violation of 7623A4, that it was inoperable.
Thank you.
Sorry.
7623, subparagraph A4.
Thank you, Young.
And what that provision states is no vehicle shall be parked upon any street while inoperable. And then inoperable, I am assuming, is probably defined somewhere in our definitions section. So give me,
Yes, I would need to know that. Yes, Your Honor.
give me a moment, see if I can find it. Inoperable motor vehicle means any motor vehicle or trailer that does not have a current license plate and validation sticker lawfully affixed thereto, or that is apparently inoperable due to being wrecked, dismantled, or partially dismantled, or having essential parts missing. It can be either one of those. So if it doesn't have a valid license plate and sticker lawfully affixed, it can be a violation of the ordinance. If it's inoperable because it's wrecked, dismantled, or partially dismantled, or has essential parts missing, it could be an inoperable vehicle. So that's the definition. The definitions comes under section 711 of the revised code. 711.
1. Okay.
All right. Mr. Reynolds, are you ready to proceed?
Mr. Randall, which photo is that? Is that 1 and 2?
So this,
1, 2, and 3?
our only exhibit for this one is PE3.
PE3. Okay.
Okay, and Mr. Reynolds, are you ready to proceed?
Yes, I'm sorry.
Mr. Lau, are you ready to proceed?
Yes, Your Honor.
Okay, great. So let's start with the first witness for the people.
Thank you. And we'll call Officer Croto back to the stand.
Officer Kroto, if you come back forward, I'll remind you that you're still under oath, sir.
Yes, sir.
All right, thank you.
I do just want to tell Mr. Lau that the pictures of this vehicle that we're talking about here are depicted in PE 1 and 2.
Yeah.
But we're only going to use PE 3.
Oh, okay. Yeah,
So
that's
if you
what
want
I
to know
thought.
which vehicle it is. That's
Yeah, that's what I
PE 1 and
thought.
PE 2.
Yeah.
Good afternoon again, Officer Croto.
Hello.
I guess you can consider yourself under oath.
Yes, I just
Okay,
reminded him he's under oath.
Great. And I'd ask at this time that the court take judicial notice of basically his intro testimony about who he is, what he does, how long he's worked there, and all of that.
Any objection to that, Mr. Lau?
None
All
whatsoever.
right, so the court will take judicial notice of the prior testimony.
Thank you. So directing your attention, Officer Croto, back to October the 11th, did you issue any tickets that day for vehicles that had expired tags?
Yes,
And did you see a vehicle that was a Ford pickup truck with a kind of like a camper on the back?
yes,
And would that have been license plate Colorado 6386618?
correct.
And can you just talk us through a little bit about like what you observed on that vehicle and what you did?
Yeah, and so yeah, we had held off on enforcing in this area for the court's request. So we had complaints that were building up. And so on October 11th, we were able to kind of answer some of these complaints that we had waiting. And so yeah, this vehicle was cited by me on that day, per complaints that were in the queue.
And was this vehicle that I referenced, the license plate number, was that cited for having expired tags?
Yes,
I'm going to approach with what's been marked as People's Exhibit number 3. Just going to hand it to the witness, and this has been furnished to Mr. Lau, and the court has a digital copy. Do you recognize that photo?
yes.
How is it that you recognize it?
This appears to be a picture from one of my citations.
And is it a fair and accurate representation of the license plate as it appeared on October the 11th this year at about 10:30 in the morning?
Yes,
I move to admit People's Exhibit 3.
Any objection to Exhibit 3, Mr.
None
Lau?
whatsoever.
Exhibit 3 will be admitted.
And was this location-wise, were you at 290 Pawnee in the city of Boulder, state of Colorado?
yes.
And who does this vehicle belong to? Or this vehicle?
Mr. Lau,
And what date is on the license, if you can read it?
it's going to be August 13th, 2024.
And so was this license expired?
Yes,
Did you observe any other license plate or validation sticker that was current, that was affixed to this vehicle?
no.
I don't have any other questions for Officer Cote.
Mr. Lau, any questions for Officer Kroto?
Yes, I do, Your Honor. So, ticket 3980 was, issued because of violation of 3623A4. Once again, the judge already said it's one or the other. So which one was it that it was being issued a citation? Abandoned, inop, or was it the other one, expired tag?
So yeah, inoperable vehicles, invalid plate tickets are generally the same thing. The inoperable has a follow-up checkup approximately a week later for an impound. The other caveat for an inoperable vehicle outside of registration would be if the vehicle is dismantled and undrivable.
So on October 11, when you issue the ticket, you issue it based on it being inoperable? Once again, I don't understand because you said that and then you said it's subject to follow up 1 week after. I don't understand what you said.
I'm sorry, that's the process for inoperable vehicles. We track all vehicles that are marked abandoned and inoperable, and there's always a follow-up that occurs. This ticket was given because there was no, the license plate was expired as of August 13th, 2024, and the ticket was written on October 11th, 2024.
So he's written it because of the license plate is his answer. The license plate being expired, not because it was dismantled or wrecked of the other provisions. Is that correct understanding of your response?
Correct.
Okay.
Your Honor, of course, Mr. Reynolds supplied these to me, PU 1, 2, and 3. And of course, he's only been addressing PU 3, which accurately shows the license, the expired. But PU 1 and 2 shows a boot on the rear wheel of the vehicle. So is it customary for you to boot a vehicle based on an expired tag upon that day?
Upon my arrival, when we checked this vehicle, it was on the scofflaw list, and so it was impounded for scofflaw. And it was also there during my checkups, so it did receive violations as well. And the scofflaw process is for unpaid citations.
So that is what you've actually also educated me earlier, that anything past $125 combined in fines and late fees would be subject to that. And sometimes your office has a discretionary to wait 60 days, maybe 30, but sometimes not. Something like you explained that to me earlier.
Why is that relevant to this issue of whether there's a license plate violation?
Because, Your Honor, this is the vehicle that was booted and towed that very day. If it is just based on a expired tag, I do not believe it would be booted and towed.
But I think he said he wasn't towing it for that reason. I think he explained that to you, but this is the only issue for me is not whether it was an improper tow or improper impound. The only issue for me is whether there was a license plate violation for that vehicle. That's all that's at trial right now.
I understand, Your Honor. You also have actually addressed the specific tow of this vehicle on that day.
I may have, but the only issue for me today is whether or not there was a violation of the license plate ordinance.
I know we are referring to this specific 3980. Was this the only ticket issue for this vehicle on that day?
I don't think so.
What would be the other one?
As I recall, I want to say that there's 2 citations given to this vehicle. One of them was for a valid plate, which we're talking about now, which is 3980. Another citation, which is 3981, that was for the camper RV trailer.
And that, I believe, is going to be the next trial. I think we have, let me just look, I can tell you.
That's my understanding.
Yeah, there'll be another trial right after this one on that other ticket that was issued to that vehicle. That's the one that ends in 3981. But I don't want to mix the testimony about that. We're going to stick just on this violation right now, which is 3980.
Thank you, Your Honor.
Thank you,
This
Your Honor.
specific vehicle has consumed the court's quite a bit of time already. So in this case, I have no further question for the officer.
Any other questions from you, Mr. Reynolds?
No, Your Honor.
And also, you can step down. Thank you. Any testimony that you'd like to offer, Mr. Lau, on this case, the license plate charge?
I do not, only because, Your Honor, you said that there is a follow-up then that is related to the same vehicle but with a camper. So I do not have.
Not on this particular ticket?
no sense in repeating myself 2 or 3 times.
Okay,
Thank you, Your Honor.
all right, thank you. So closing arguments, Mr. Reynolds?
Yes, Your Honor, very briefly, that the city believes it's proven beyond a reasonable doubt that this vehicle had an expired tag.
Any argument that you'd like to make, Mr. Lau?
No, Your Honor.
All right, on the case number for the ticket that was issued,
Oh.
it ends in 3980, and I'll be very clear, it's 242-147-03980. This is the citation that was issued October 11th for the license plate with 6386618. Officer Crosso testified that this was the registered owner for that vehicle is Mr. Lau, and that the plate expired August 13th of 2024. There's a corroborating photograph that shows a picture of the vehicle with the plate showing that the registration was expired as of August 13th of 2024. The city has proved beyond a reasonable doubt that the defendant has violated that specific subsection, which is 7623A4, and that requires that indicates that it's a violation of city ordinance to have a vehicle that doesn't have a valid registration with a lawfully affixed sticker. There is proof beyond a reasonable doubt of that violation, so I will find the defendant guilty of that violation. All right, let's turn to the next case, which is, as I mentioned, the one that ends in 3981.
No, he wouldn't be a
I'm going
vexatious
to pull that
litigant.
ticket up right
He just
now.
keeps getting tickets.
This was issued also
Vexatious
on October
litigant is
11th of
someone who's
2024 at
bringing the action.
10:38 a.m. This is alleged to be a violation of
depends
the
on the
camper
statute.
RV and
That's the
trailer
idea.
parking prohibition. That's section 7624B. Is that correct, Mr. Reynolds? We're proceeding under that same
Yes,
section?
same allegation as our first trial.
Okay, the 7624B it's the same as the first trial that we had, and the allegation is that the camper RV or trailer was parked in violation of that ordinance at 4660 Sioux Drive on October 11th at 10:38 a.m. All right, so we will ask the prosecutor to go forward with the next, with the witness on that case.
Thank you, Your Honor, and we'd recall Officer Croto to the stand.
And Officer Croto, I'll just remind you, you're still under oath.
Yes, it's PE 1 and 2. Exhibits on the-
Oh, that's why you were, okay. Thank you.
And whenever you're ready,
Thank
Mr.
you, Your
Reynolds.
Honor. Good afternoon again, Officer Croto. I would ask the same thing of the court to take judicial notice of kind of the intro testimony for for Officer Croto that he provided in the first trial today.
Any objection to that, Mr. Lau?
No objection.
All right, with no objection, I'll take judicial notice of the prior testimony from the first trial on the background for the officer. Go ahead
Thank
whenever you're ready,
Thank
Mr. Reynolds.
you, Your Honor. In the Officer Croto, we're on to the third ticket that was issued on October the 11th at 290 Pawnee. And again, is that in the city of Boulder, state of Colorado?
Yes,
And so we're talking about a Ford pickup with a camper type object attached to the bed of the truck. Is that recalling this vehicle for you?
yes,
And is this vehicle Colorado license plate 6386618?
yes.
And I want to ask, kind of similarly, did you issue a ticket that day for parking a camper or trailer in violation of the 48-hour rule?
Yes.
And so that vehicle, can you tell us what is the earliest record that you are aware of seeing that vehicle parked on the city street in or around 290 Pond?
All right, yes, I have some information for you. August 5th is when the warning had started for this vehicle, for this ordinance specifically. August 7th is when the first citation was given to you. And then on this day, on October 11th, I did write another citation to it.
And so you have records of seeing this vehicle on August 5th and August 7th, and then not until October the 11th. Is that accurate?
Yeah, as it pertains to this ordinance, correct.
Okay. And between August 7th and October the 11th, did you ever go to 290 Pawnee?
Yes,
Did you ever see this vehicle on any private property there?
Not that I recall.
I mean, would you have, do you think it would have stuck out in your memory if you had seen this Ford F-150 with the camper on the back?
No,
On like the.
you just lose. You're just
on
going
the,
to lose them all.
On like the
Like
grass in
another
front of
remedy.
the house.
I can't specifically recall.
Okay. And did you issue this ticket on October the 11th?
Correct.
And how confident are you that this vehicle was parked longer than 48 hours in front of 290 Palmy?
Per my checkup on August 7th, it was in violation of the 48-hour rule and it received its first citation on August 7th.
And did you see, okay. I'm gonna approach with what's been marked as prosecution or people's exhibits 1 and 2. Officer Croto, can you just review these?
Yeah.
Do you recognize those pictures?
Yes.
How is it that you recognize them?
These appear to be the pictures for my citation from that day.
And do they appear to be a fair and accurate representation of that vehicle?
Yes.
I move to admit people's exhibits 1 and 2.
Any objection to exhibits 1 or 2, Mr. Lau?
No objection.
Okay, exhibits 1 and 2 will be admitted.
I don't have any other questions for Officer Croto.
Mr. Lau, do you have any questions for Officer Croto?
Yes, I do, Your Honor.
All right, go ahead whenever you're ready.
Mr. Officer, that specific vehicle with the plow and also with the expired tag has been parked on various occasions on the side yard of 290 Pawnee, which you have issued multiple tickets.
Okay.
So, and that would be in your T2. So can you now have better recollection or correct yourself that you've never seen it on a private property? Because you've physically taken that vehicle on several occasions on a side yard.
I don't recall specifically, no. There may be a record in T2, but I wasn't prepared to bring any of that prior information. It's only pertaining to this citation.
Let me make sure I understand. Are you saying you don't recall whether you issued a citation for it in the private yard area?
Not from my memory, no.
Your Honor, so the burden of proof is for me to show a photo that it was on the side yard or something like that, or do I need to have a timestamp or whatever?
Let me just be
Anna,
clear about burden of
Because
proof.
he
The burden of proof is,
specifies something that I believe is not factual.
nobody has to have evidence of photographic evidence. Testimony, people can offer testimony and I can give whatever weight I choose to give to testimonial evidence. So the officer can testify, I don't recall ever issuing a citation to the vehicle on a side yard, and that can be credible evidence as far as I'm concerned, but it also could be something that you can offer countervailing testimony when you testify. You could say, I recall it being on the side yard on this, and this date. Neither
about
of
I'm
you
not
have
your
to provide
attorney?
a photograph. It's always more helpful.
If
for
you
me
don't know
have a
how to
date
do
stamped
this, get an
photograph, but
attorney.
that's not the only type of evidence that I can consider. And the burden of proof is on the prosecution to prove that this vehicle violated section 7624, not on you.
Yes, Your Honor, I have actually truly followed what you've been saying. It's just that I'm also trying to double multitask and actually look up the photo, at least one photo of it being on a side yard, either showing that it has
Double
received a ticket
multitask.
or something to that effect. And I'm just having a little slow scrolling. So,
Okay, I'm convinced now. This is a Chi-Com plot. They sent this guy over here just to gum up the works and see how stupid we'll get. It's got to be. That's the only explanation that makes sense to me.
Well, Your Honor, whether I show it now or show it later, but I do have, of course, I have multiple photos, but I only have one with me on my phone right now that shows it on my side yard receiving a ticket issued by the officer.
Do you want
This-
to show him that photo and see if he recognizes it?
Thank you.
And Mr. Reynolds, if you need to see what he's showing, feel
Yeah.
free to come forward. And then just tilt it towards me so I can see what you're showing him as well.
So is there a timestamp with this? I do see the ticket on there.
Took me, as you can
Just
see,
let him ask you questions, officer.
two or 3 minutes. Sorry.
I
Can you see that? Yeah.
Yes.
So that has the ticket, that has the plow.
Why don't you ask him
Oh,
questions? Yeah.
sorry. That has the ticket, that has the plow, so I'm sure.
It does look like the car and it does look there was a citation on there. I'm
Yeah.
unsure of the date, because I don't see the date on the picture.
Thank you. I'll go back to my-
I don't see how he's getting to show him a photo that's not in evidence. It isn't laid a foundation for. I mean, call me old fashioned, but
Based on your testimony earlier,
in
and
Chicago,
now at
we
least have seen a
do these
photo
law
of a
things.
ticket that you have likely issued yourself. Would you like to correct you or modify your testimony?
No, because there was no timestamp for that picture, so I'm unsure of when that was taken,
No, I don't.
The,
We don't know when your picture's from.
as it would pertain to the ordinance.
There's no testimony. It's not in evidence. Why are we looking at it?
given the benefit of more time and so forth, I would be able to show multiple pictures, multiple timestamps. But in this case,
Yeah, you could, except the
we
trial
are still
today.
referring to a vehicle that has been subject to multiple tickets, being towed by parking already once, and so forth. I have no further questions for the officer. Go on.
Mr. Reynolds, any redirect?
Just briefly, Officer Croto, on October the 11th, when you issued this ticket to this camper in violation of the 48-hour rule, why did you issue that ticket?
I had issued that ticket because a watch had begun on this vehicle for this citation on August 5th. And then a real citation was issued on the 7th, which was 48 hours after. And per section C, it is not a defense for the vehicle to be on the city street after that.
Do you know when the boot got put on that truck?
Yes, it's a standard operating procedure. Anytime that there is a vehicle that is being impounded for scofflaw. When we came to the vehicle, it was in violation and it was on scofflaw list.
So was the boot applied on the 11th of October?
Correct, yes.
How from a not certain at all to 100% certain, how certain are you that this camper was parked longer than 48 hours on the city street?
I am fairly certain, as I've been checking on this area per the complaints. I'm the primary officer for this location, as there's been a lot of complaints in this area.
And when you say fairly certain, do you think there's any possibility that this vehicle had only been parked there for like a day?
I don't think so.
Okay, no further questions.
Do you have any questions based on those questions? Mr. Lau?
Yes, Your Honor, I do. You said the boot was put on that day. Do you recall roughly the approximate time, 10 a.m.-ish, 11 a.m.-ish, thereabouts?
It would have happened right before the citation was issued, as the boot is applied in the pictures for the citation. So that was the first thing that we saw, was that it's on the scofflaw list.
So if the citation was issued around 10:30, would have been somewhere in the 10 o'clock hour?
Yes, yeah. It happened right before the citation was issued.
So that is a Friday. And I will save this remark for my closing on this specific ticket. But, so. I have no more further questions.
Okay.
The officer.
I've got a question for the officer, and officer, I want you to let go of the idea that once a vehicle has been parked on a city street for 48 hours, like in August, that it can no longer be parked on a city street at some other time, a trailer, regardless of what you've been instructed by others as to how to interpret the ordinance. Just leave that aside for a moment. Because my question, and I don't know that I heard Mr. Reynolds ask it, but I think sometimes because of the context of where people are thinking of something, they think, well, because I know once it's there, it can't ever be there again. I may interpret the ordinance differently than you've been told. From the 2 days prior to October 11th, which would have been October 9th to October 11th, that's a 48-hour period starting from 10:38 a.m. on October 9th to 10:38 a.m. on October 11th. Did you happen to see that vehicle parked in that location during that time frame on that street?
I might have pictures on my phone.
So do you want to take a moment to see
I
if you
would be
have?
very interested
Yeah.
to see that.
Let me just double check, because I was.
Take a few moments, we'll pause and see if you have some evidence that you can offer on that point.
I got pictures from the 11th. So no, I don't have any in my handheld for the 9th.
Are you going through?
Well, I'm going to give you a chance to ask
Sorry,
questions.
sorry.
I'm asking questions right now, and then I will give both you guys a chance to do follow-up. So nothing between, for the 9th or the 10th on your phone?
I don't know. I have a bunch of pictures from the 11th, because that's when we were permitted to go back to the property.
Got it, okay. That's the only question area of inquiry. Mr. Reynolds, any questions based on my questions?
No, Your Honor.
Mr. Lau, any question based on my question, which is if he had any memory or evidence relating to that 48-hour period from October 9th at 10:38 a.m. to October 11th at 10:38 a.m. Do you have any questions for him based on his answers to what I've asked?
Yes, Your Honor, I have, in this case, unfortunately, better recollection of that time period.
Just questions for him, not comments, just questions.
So, okay, the comments I would say for the closing. The question then is that you testified, you feel quite certain that that vehicle was there in the exact spot for 48 plus hours.
Yeah, correct.
But once again, it's based on recollection, and you were even with additional attempt, you were not able to, whereas I was able to show you, not necessarily during that specific
Question,
time
not an
period,
argument.
but that you have issued tickets to that specific vehicle sitting on a side yard. So hence not on city street.
I would be unsure if that citation was issued in between the watch. The watch was started on the 5th of August.
The watch was started on the 5th of August.
Correct. And it was still there on the 7th, which was 48 hours afterwards. So it received its first violation. And per subject, the section C is why it received another citation that day.
So in August, that was the first tracking that you've done.
Correct.
In specific. And regardless whether it was off the city street, subsequent to that, you actually you testify you think so, but you don't have actual physical proof. I've also shown you a picture that was on the side yard. And most likely after your initial morning tracking of this vehicle, can you reconcile that for me, please?
No problem. So per PE2 and PE1 would be the proof that that vehicle was on the city street. Per subsection C, the camper RV trailer ordinance.
Okay, once again, we may be down to the interpretation of whether it's city street forever or not. So I have no further questions.
Okay. And I think you're right. And we'll talk about that. All right. Any other questions for you, Mr. Reynolds?
No, Your Honor.
All right, officer, you can step down. Thank you. Now, Mr. Lau, Mr. Reynolds, any further evidence?
No, Your Honor.
City has rested this case. You can testify. Remember, closing argument isn't testimony. So if you want to testify, you have to do it under oath up here. And we're now talking about the incident from October 11th at 10:38 a.m. Ticket number 3981, and the allegation is that the vehicle, the Ford F-150 trailer was parked in violation of section 7624B. So if you'd like to offer your own testimony, you can. You're not required to, but remember, the only evidence I have so far comes from the officer. Anything you've testified to previously doesn't have anything to do with this particular trial.
I will testify.
Okay, come on forward. I'll just remind you, you're still under oath.
Yes, Your Honor.
Oh, sweet Jesus. What?
And go ahead whenever you're ready.
Thank you, Your Honor. So once again, this is regarding the 96 F-150 and so forth. And the ticket was issued on October 11th. And of course, turns out 2 tickets, but, and then of course it was told exactly the same time. If you may recall, Your Honor, and this is the morning of me being advised by Mr. Reynolds and actually by you in court on October 8th, the Tuesday, regarding the code enforcement complaint that I should come to traffic court at 1:30. The further, of course, the so-called city manager's overnight parking permit was told by the supervisor of parking, sorry, the lady's name escaped me off the top of my head right now, that there will be no enforcement because of the city manager's overnight parking permit until the code enforcement case on October 8th. So I felt although the officer has testified that they've been monitoring it since August, I, of course, have already provided visual proof, photo proof, that at least it hasn't been on the city street for that whole duration. I, of course, have also stated earlier that I believe that I'm testifying that voter parking in issuing 2 tickets and an immediate tow of the vehicle, and of course other tickets earlier to make it qualify the scaffolding law, is based on the fact of a vindictive action on the by a Boulder government department and employees. Other than that, the relentless persecution of me and my vehicles still fails for me to comprehend. That's my testimony.
Any cross-examination, Mr.
Still
Reynolds?
fails for me to comprehend.
Mr. Lau, when was that vehicle before October the 11th
it's so good.
last moved?
It was moved definitely after the October 8th court case, because I know my overnight permit, city manager's permit, would expire on that day. So I move it. And so yes, it was not in that specific location during that 48-hour period prior to it being ticketed.
And where was it?
Side yard or on Pawnee instead of on Sioux Drive. Pawnee runs north-south, Sioux runs east-west. But of course, 290 Pawnee is a corner lot, so it covers both. It touches both.
And so your testimony is that it was last moved before the location it was in on October the 11th. It was moved from another city street.
I have room on the side yard, so it would have been on the side yard. But I had to move other stuff per code enforcement compliance. So the vehicle may have been, it was on the side yard right after the court, right after October 8th code enforcement court. And to the side yard, it may have been moved back to there to facilitate me moving out things from the side yard, because there is a gate, big things, bulky things. So it likely would have been moved back on maybe the 10th.
And so when you say side yard, you mean like the actual yard, like the grassy area?
Yes, 290 Pawnee, the side touching Sioux Drive.
Okay, I don't have any further questions.
And I already show a picture of where I would have parked it, because I have been parking it there on and off. Thank you.
No other questions?
Well, I guess based off that last answer, I do have another question. Mr. Lau, when was that picture that you showed Officer Croto taken?
Yes, I was able to, of course. I have more additional ones too, but August 23rd, this specific picture. So I'm sure the T2 would be able to bring up some tickets issued on the August 23rd or 22nd or 21st or something like that. This specific picture or that specific picture.
That picture depicts the vehicle parked on the side yard?
Yes, of course.
Okay. No further questions.
Okay. Mr. Lau, you can step down.
Thank you.
Will you shut up?
Any other
Now we
witnesses or
see the
evidence you'd like
violence
to
inherent in the
present, Mr. Lau?
system.
No, Your Honor.
Any rebuttal case from the people?
If I could just have a moment.
Maybe we could hook him up with Lori Vallow. Just a thought.
Nothing further, Your Honor.
Okay. Closing arguments.
We would submit essentially the same closing argument that we made for the previous vehicle in the same situation.
Would you like to make a closing argument on this case, Mr. Lau?
Yes, Your Honor, but Your Honor, we have one more ticket to go, but
Yep, just on this one. Just this one.
Yes, but we, at least, the defendant, me, in this case, still stuck on the interpretation of 7624 C, yeah, which is interpreted by parking and by city prosecutor as forever for a trailer, RV, camper, whatever. And my interpretation of that is quite different. My closing would, in this case, would be, since that is being applied here for ticket 3981, 3981, even it's clearly not stated, but even if the 7624B does not clearly stated that it's a forever thing, hence the
Forever,
and I
ever?
believe this came about because Boulder, City of Boulder is a home rule government, yes?
Well, the City of Boulder is home rule. I'm not sure what came up.
So they can create ordinance and regulations like this.
They have the legal authority to create
Yes.
regulations applying to local community issues, yes.
So this would then still be, if that is interpreted as forever, I believe this
Ever?
ordinance is in violation or maybe in contrast to state law, and most likely federal has traffic law. I believe federal has traffic. But yeah, I am not the subject matter expert on any of this, but I believe it would be a overbroad or incorrect interpretation if it is forever ban on a City of Boulder street based on, once again, based on 76224B. Thank you, Your Honor.
Thank you for that. Mr. Reynolds, you want to respond to that argument? I am going to address the legal interpretation on this particular case in more detail. I addressed it initially in the first case. I'll address it in more detail here, and then I'll do it in writing as well. But if you want to make an argument, feel free.
Your Honor, I'll state that the, plain language of the ordinance should govern here, that, somebody has 48 hours to park a vehicle like this until it's in violation of the city code, and to be in compliance, then it must be completely removed from the street, and it would be a kind of I would say a bit of a stretch to say that somebody could take a vehicle to some private property for like for a limited amount of time and then allow it to continually be parked on the street. And Officer Croto testified that over a period of much longer than 48 hours that he did encounter this vehicle parked on a city street.
So I have a question for you, Mr. Reynolds, and I'll allow both of you, because this is an interesting and applicable issue, I think, is the interpretation of this subsection C. If a person owns a trailer, perhaps it tows their motorbikes. They might have some dirt bikes or something like that. And they have a trailer and they park it on their driveway. It's private property, right? And they drive it off that property one day and they park it in front of their house for 48 hours. Maybe they're loading and unloading the bikes, or they've got a trailer that's got, it has other things, their belongings in it, and they're moving things in and out of their house. And then they park that vehicle back on their, and they have it there for 48 hours, and then they park it back on their property. Are they not allowed to go back out some other time and have it back out for 48 more hours in front of their house while they unload it and load it?
It does seem like the ordinance permits it to be a 48-hour occurrence.
A one time in the life of the vehicle.
It does seem like that is how the ordinance is written.
It's
Mr. Lau,
not
you've already made your argument. You think it's overbroad. But anything else you want to say?
Yes, of course, I think, thank you, Your Honor. I think it's, but this is shorter. I think it's overly broad. If there is the clearer language that on streets, if there's on the city of Boulder streets or whatever, so that at least may lend more credence to Mr. Reynolds' interpretation. But unfortunately, in this case, Boulder Parking is enforcing it based on the loosest concept of thinking of the actual wording that is passed by council. That's my point.
I'm going to pause for a moment, let Mr. Reynolds gather his for one last argument. I'm going to tell everybody, I'm going to take this case under advisement, but I'll give Mr. Reynolds some time.
So, Your Honor, given the, I just talked to Officer Croce a little bit, and the way Parking Services interprets this and is that if the vehicle is moved onto private property from the street, then kind of like restarts the clock. So because Mr. Lau has shown that through that photograph that he moved the vehicle from the street to his yard, which I think is actually a separate violation, but not the one that's subject of this trial. And I did confirm with Supervisor Flesh that there was a citation written to this vehicle for being parked on a yard in September that that we were just going to move to dismiss this citation because I don't think that we have the proof anymore.
Okay, and so I'm going to accept the motion to dismiss, but let me make sure it's clear to you what I just heard from an interpretation perspective, because I think it is very important for everybody to be on the same page with these ordinances, what the court's view is, because ultimately, they give me the rope, so I'm the one that has to decide how to interpret this ordinance. City council, they're the executive body, they're the legislative body, they create the ordinance, the executive body has to go out and carry it out, and they make an interpretation based on what they think the ordinance means.
Yeah, he went to law school.
But ultimately, when it comes down to the law, ultimately the judge has to decide what he thinks the ordinance means. And
we're doing schoolhouse rock.
that's why I asked the question to Mr. Reynolds, is it would not, in the court's view, be a legitimate reading of this ordinance to say once you've used up your 48 hours of having your vehicle parked on the street, your trailer, that you could never park it on the street in front of your house again. I would probably have to go through and do a lot of legal research and read the minutes of the actual hearing where they agreed to this ordinance back whenever they did agree to it to try to get any other information. I think it reads clear on its face that there is this 48-hour rule and that you can't just move it within that 48 hours to another spot, or when the 48 hours is over, you can't just move it to another spot on a city street. But I do think the clock should restart. And that seems to be what the executive branch has decided as well, is that if a vehicle is in compliance during a period, if it's there for 48 hours and then it's moved to a private location, at some point that clock starts again. There's nothing in the ordinance that says how long it has to be off the city street for that clock to start again. The ordinance is silent to that.
Or that there is a clock.
But it would not be, in the court's view, a legitimate exercise of the city's police power to prevent someone from parking their trailer on their in front of their house ever again because they've used up the 48 hours for parking it on a city street. That seems like an unfair exercise of their police power, and so it wouldn't pass constitutional muster if I were looking at it from a rational basis perspective. I think there would be some arguments, and there might even be some others as far as constitutionality, but it also might just be a straight legislative interpretation argument that I would have to work through. And to some extent, the city has acknowledged the interpretation that I might put into writing, and I'm going to try to do this in writing so it's really clear for everybody, and I'll do it in a more legalistic way than I'm doing today. But I do think that there has to be some understanding that if someone is in violation, the city is going to have to prove that the vehicle was on a city street for 48 hours consecutively. It doesn't have to be in the same exact spot. So if you moved it around to the side of Pawnee, that wouldn't be a defense, Mr. Lau. So if you parked it in front of your house on the Sioux side and you parked it there for 46 hours and then you moved it to the Pawnee side and it was there for another 2 hours and a minute, it's still been consecutively on a city street for 48 hours. You see that? Moving it wherever. If you moved it to Table Mesa Drive, it's still on a city street. And so you couldn't park it on a city street for 48 consecutive hours. Does that make sense?
Yes, Your Honor.
All right. So I want to make it clear to you leaving, because I'm also going to do something in writing. But because Mr. Reynolds has dismissed the case, it'll just be a note that I put in one of these cases. But I want to make that clear both to enforcement and to you that it doesn't mean that you can't move that vehicle. And it would have been a harder case with the F-150 because in the F-150's case, it's easily moved to it would be something that you could actually find space on a private yard. And there wasn't any information on the big trailer that it had been moved anywhere than simply being on a city street. So I find you guilty on that one. But on this one, he's dismissed it. I just want to make clear that you can't park your vehicle, whether it's in front of your house on the Sioux side or in front of your house on the Pawnee side, for that trailer for longer than 48 hours. And if you park it for 47 hours and move it somewhere else on a city street, that's not going to be a defense. All right. That doesn't mean, as perhaps there may have been some testimony here saying you're forever banned from having that vehicle parked on a city street. The clock does restart, as Mr. Reynolds has indicated after his conversation with Officer Flesh, is that they do interpret this as this clock does restart after that 48 hours. And based on the information that you provided during the trial, it was clear that it was moved from the last time that Officer Croto saw the vehicle in August to the time that he saw it again in October, at least to the time that he could testify that he saw it. He may have seen it dozens of times, but he couldn't testify to any of that. And for my purposes, I'm going to need to have testimony that vehicle was parked on a city street for 48 hours prior to the ticket being issued. That's what makes these things really clean and easy for the court. But in this case, the prosecutors dismissed it, so we're going to move on to the other. I will do a written order so you'll have it.
Your Honor, I thank the court for the clarification, the insight, and actually the interpretation. But what the court have all just said applies exactly also to 3987.
Not quite.
Trailer, because I already testified under oath that it's been moved to a side yard. And
Not during 3987's case. You did not testify to that.
But I said it's been issued tickets while it was on the side yard, and it would be in the T2 system. Obviously, the more senior officer is able to bring up the information regarding 81. But in this case, I was too consumed with the forever aspect of it that, of course, I obviously did not convey myself appropriately on 87, on 3987.
3987,
that evidence
evidence.
the same situation.
Well,
Because there were tickets issued for that exact trailer on the side yard of the house.
I only have the evidence that's given to me during a trial, and during the trial, that's why I make each trial separate.
How may I ask the court to reconsider on one specific trial or on one specific thing?
I'm not going to reopen 3987. I had the evidence that I considered in that trial. It happens all the time in cases where people discover other evidence and they want to say, oh, I wish I'd have done this. The time to find the evidence to present to me is prior to trial, because then I don't have to go back and correct things and say, oh, I just discovered this. Come back to me 2 weeks later and say, Judge, I want to reopen this case. I'm not going to do it that way. The time to present evidence on the issue surrounding the bigger trailer that was there in case number 3987 was during that trial. And the only evidence I had during that trial was that it was there and had been there continuously. This trial was different because there was evidence presented surrounding that vehicle being moved to a side yard. I didn't have that evidence in 3987. I'm not going to reopen that at this juncture, because it wouldn't be fair to any of the parties to keep reopening simply because someone's got some ruling that might be advantageous and they want me to consider new evidence. The evidence has been presented. I've heard it. That ruling will stand.
You lost.
But you've earned a dismissal on the third one. We're going to go to the last trial today.
Thank you, Your Honor.
And let me just articulate.
My God, this guy's insufferable. Okay, so the judge just leaned for you. It is a crappy ordinance in that it's not well defined. So then that sort of leaves it open to interpretation by the judge. The judge gave it, I think, a reasonable interpretation. I think roughly what people mean, but we still don't know, for instance, what resets the clock or if a clock even exists. But that is a reasonable interpretation of the statute. But he leaned for you at that. He gave you that. And then he's like, no, I want to go back to the other. Well, you didn't present the same evidence in the other case. There were different circumstances, and you're an a-hole. Just be happy. You got one.
Articulate for everybody what we've got in the last trial. And this is the citation that was issued 3991 are the last four digits of that citation number. That was issued also on October 11th at 11:40 a.m. This was a valid license plate charge that was issued for a vehicle parked at 290 Pawnee Drive. So that's the allegation in that particular case. And it just says a temporary license plate had been expired as of September 20th of 2024. So that's the allegation, is that it was not a valid registration or license under the inoperable provisions of section 7623 subparagraph 4. Mr. Reynolds, are you
Thank
ready?
you, Your Honor. We all recall Officer Croto to the stand.
All right, Officer Croteau, I'll remind you, you're still under oath.
And we would ask the court to take judicial notice of all of the intro information in the first trial for Officer Croto.
Yes, I will take judicial notice. No objection to that, Mr. Lau?
No objection.
I'm good, Greg.
And so, Officer Croto, the fourth ticket that you issued on October the 11th at 11:40 in the morning, do you remember encountering a box truck that day?
Yes, I did encounter a Isuzu box truck, a big blue box truck.
And I'm just going to approach what's been marked as People's Exhibits 6 and 7, copies of which have been furnished to Mr. Lau, and the court has digital copies. Do you recognize these pictures here?
Yes, I do.
How is it that you recognize them?
They appear to be from the citation that I had written that day.
And did they appear to be fair and accurate representations of the box truck and the license plate area of the box truck?
Yes.
I'd move to admit People's Exhibits 6 and 7 into evidence.
Any objection to exhibit 6
No
or
objection.
7?
Um,
Those will be admitted.
And Officer Croto, this was at approximately at 290 Pawnee in the city of Boulder, state of Colorado.
Correct.
And what did you issue this box truck a ticket for?
And received the citation for not having valid displayed plates registration.
And on People's Exhibit 7, I believe that's the license plate. Can you tell the court when did that license plate expire?
It expired on September 20th, 2024.
And you were there on October the 11th of 2024?
Correct.
Did you see any other plate or valid sticker lawfully affixed to the vehicle that was current?
No.
I don't have any other questions for Officer Croto.
And I'm sorry, did you testify about who the registered owner was? I may have missed that.
No, he did not.
The who does this vehicle belong to?
Mr. Lau.
Then I don't have any other questions.
All right, Mr. Lau, do you have any questions of Officer Croteau on this particular citation, 3991?
Yes, but I'll keep it a little bit brief. So once again, this it's initiated because of a specific complaint about this specific vehicle being parked right in front of 290 Pawnee Drive, and then you responded to it. But and do you recall roughly when that complaint was made?
Not offhand. It would have been before the 11th. We were holding all complaints due to a code compliance. We were told to hold off until September, and then it got pushed to October. So we had to wait to answer all of our complaints until then.
So thank you. is there any record that you have, whether it's in T2 on your phone or on some other means that you can convey when the complaint was actually made, a rough approximate time, and hence your enforcement action?
I'm not objective relevance.
Sustained.
I have no further questions, Your Honor.
Any redirect?
No, Your Honor.
All right, officer, you can step down. Any other evidence for the people?
No, Your Honor.
People have rested their case. Mr. Lau, did you want to offer testimony on this case?
No, Your Honor.
All right, closing arguments then, Mr. Reynolds.
Your Honor, the people believe that we have proven beyond a reasonable doubt that this vehicle was properly issued a citation for it being inoperable due to its expired license plates.
Any argument from you, Mr. Lau, on that one?
No, none, Your Honor.
I think the evidence is clear and beyond a reasonable doubt on that particular citation. That the defendant
I had the
guilty of
same
being the
thought.
owner of a vehicle that had a license plate that had expired, which is a violation of section 7623, subsection 4 of the Boulder Revised Code, and it was parked on a city street without a valid registration. So I will find the defendant guilty of that violation. All right, so that takes care of the 4 trials that we've had today. The next step for me will be to see if we can address what we've still got pending and try to get additional trials, if that's in fact what you want, Mr. Lau. The city has now kind of they've heard my interpretation of 7624. I don't know if there's other cases involving that. It may be worthwhile for all of you to have some follow-up conversations. I don't know if they're going to be worthwhile or not. There hasn't been much progress made previously, so it may be a waste of energy. It may be better to just figure out what we've got on our plate and get some trials scheduled. Mr. Reynolds, what do you think? You haven't had the benefit of looking at all the cases that are out there,
I
right?
guess I don't know what the lay of the land is in terms of how many citations we would potentially be looking at. I bet Mr. Ogden is maybe in the photo or the parking system to see how many tickets we could potentially be looking at for a trial setting.
Let's pull up Ames if we can. I'll look at it too, Greg, and we can see what we've got there. Just so everybody knows, when I say Ames, I'm just talking about our parking. It's no longer T2. We've moved to a new system.
I noticed the tickets looks completely different.
Yeah, there's a new company that is our vendor, and it's called Ames. And so these citations that you'll see now are issued through that vendor. But all of the prior tickets are now in this system.
So just a side, sorry, unrelated. So Ames is also the same company that deals with the CEU Boulder campus parking, right?
I don't know if I knew that or not, but Greg probably does. I don't know if that's true. Greg, can you tell me a license plate number or account number? What's the best way? Probably.
The best way actually is to look up by Mr. Lau's last name, Your Honor, because he's got multiple plates.
Okay, so where should I go here?
Go to accounts and account search, and then you just type in Lau in the last name field, and it brings up everything.
Okay.
And then you can sort the citations. Yeah, just hit X on it. Tickets. And then if you sort
it by
the status.
The warnings we're not worried about.
Right.
That goes to issue.
So I counted about 61 worth of tickets on various plates.
Okay. So. Did you hear that?
I heard 61.
61, that's the number that sticks out for all of us.
It had 61 in the last 14 days.
No,
Well, no.
14 days.
And that's part of what we would have to go through is when Mr. Lau was here on October 11th. Well, I can't remember what date it was when you were here. You came in to argue about your parking tickets on the 11th. The 8th was the day that you were here for code enforcement stuff. You came in on the 11th to argue about your parking tickets. And I said, at that time, we had some conversations about all of the tickets. And I said, if you'd like to set them for trial, the only ones that I think you were there for part of that conversation. It was a pretty lengthy afternoon we had. And I said, you're only entitled to have trials on the ones that you've requested within 14 days of issuance. So anything that was issued on prior 14 days back from October 11th, he made an oral request to have a trial on. And so he's entitled to have a trial on those tickets that would date back to somewhere about around September 28th, something at 27th.
Sorry, Your Honor, if I may clarify. Yes, I was here in traffic court on October 11th. I had vivid memory. Once again, it's because it was a Friday.
Yes.
And the Tuesday I saw, I was in front of Your Honor,
Yes.
but not as a defendant. I requested that subsequent to October 11th because the vehicle was towed, and of course, while that morning, but of course, Your Honor, you set a trial for the to decide to rule on whether the toll was correct or not.
That's right.
And lots of conversation on additional tickets happens.
That's right.
Not on the 11th, but when I actually appear in court, I believe on a Monday, 1 week after that, or something. Sorry, your system can.
It will know.
It's more.
It will know, but it's going to require some
Yeah,
work for us to figure it all out.
So that's the day that it actually is that day, I believe, that we, in consultation with with the objection from Mr. Reynolds, to say that only 4 qualifies under these timeframes.
So you think that happened on a later date?
Yes.
That doesn't necessarily help your argument. You understand that?
It only helps my argument because I requested the court to add the additional ticks because the date for this current 56-55 thing with that actually all this happens after when
What day was that?
5472 was decided.
I don't know what we're talking about.
We're talking, when did we set the first trial date in 56-55? It'll show on this.
Yeah.
In full court, you can look it up.
Yeah, if you can help me as well.
The first trial date was
When did we do the setting? Not the trial date itself.
October 22nd.
October 22nd.
Yeah.
So on October 22nd is when you say you were here, and that was for the impound hearing. You came in October 11th. You came in. You tried to see what you could get resolved. And we talked about resolving some cases.
And I paid the fine.
Yes. And then we ultimately said, okay, we're going to set this over for an impound hearing. And then you came for the impound hearing, and
Yes.
that I believe was October 22nd.
Yes. So yes, I believe. The current 56-55 was set on October 20th. So and that is why I. Once again, with Mr. Reynolds' conversation email back and forth regarding the discovery, that's why I was able to get certain information. But once again, I specifically asked, I appear that Monday for that. And on Wednesday, Your Honor, I came back in the afternoon at your invitation, and I was here. But at that point, I have already received that pile of tickets that I show you in court.
Right.
That Your Honor did actually quickly look up as well.
Yes.
So, my understanding was that would be included.
And that's a
with,
fair,
56.
that's a fair interpretation.
Yes, but I follow up with a specific email on October 29th to make sure that I did not, because I was.
Let me be
under
clear
lots of
with
stress.
you. My inclination right now is that any ticket that was issued 14 days prior to October 22nd, so anything from October 8th going forward, you've made a request for a trial.
Yes, Your Honor.
All right. That's a pretty broad, liberal interpretation of your request for trial, but I think it was consistent with what you were wanting to do as of October 22nd, which is to have all these cases scheduled for trial. And
Yes.
so I'm sharing that with Mr. Reynolds because he has to look at it and say, okay, which ones do I have to think about, we have to trial? There's tickets in the system that, if you look on page 2, Greg and I are looking at it, of the issued tickets there were tickets issued October 11th. All of those tickets from October 11th going forward to today's date are eligible for trial.
Yes, Your Honor, I believe that because
You're not getting an argument from me.
No.
So let's spend our time on something more important.
the broad part only refers to the tremendous number of tickets I received. The broad part does not refer to me trying to take up the court's time.
So we've got from any ticket that was issued after October 8th, because that's the 14-day cutoff, if they were issued before that. And there are many that were issued September 26th, September 19th, all the way back. You can keep going back in our records. There are tickets that were issued July 1st. And then I think that's probably the last. Then there were a number of warnings. Yep. So July 1st through September 26th, you lost your right to trial on those because you didn't ask for a trial within the 14 days.
Your Honor, I understand, and I did not realize about that. But
And that's the law.
Thank you. No objection from me, Your Honor.
For you, that still means there's a lot of cases that are still eligible for trial.
Boulder Parking's been very active on my situation.
It is the truth. So what I would like to do is, there's no way we're going to do all of these. But I think the best way to do this, because I think to better use everyone's time, rather than try to figure it out in this moment, Mr. Reynolds and Officer Flesh, I think to try to figure it out in this moment is going to be too hard. So what I think we'll do is, and we can do this by phone. Do you have access to Zoom? Can you do Zoom video? We could have a quick settings hearing. We could schedule it for a settings hearing. Would allow you to work with the parking services to figure out which ones we want to go to trial on, and we can schedule them for 2 or 3 or 4 different dates. But there's way too many to try to do in one trial day.
Your Honor, I've been able to communicate with Mr. Reynolds quite efficiently and effectively through email, although we may not necessarily agree on the same terminology or this and that. To me, it would be more of a challenge for me I'm already overwhelmed with the pictures and the earlier T2 version. Mm-hmm. So if I may only have an email type of trail for either it's between me and Mr. Reynolds or between me and the court, because the court has already earlier given me 2 pages of certain of vehicles that was on the T2 list already. And that has been very helpful to me to understand the situation. Because otherwise, with the 61, Your Honor, I am simply overwhelmed. There's no way that I can mentally, via Zoom, follow that.
That's why we aren't going to have trials on, and I just counted, I think there's 29 cases that are potentially set for trial, because I've looked at the ones from October 11th and October 8th forward. And I believe there's 29 if I counted them up correctly. Everything else prior to that, they're already in default status. You can't do anything about them. You don't have the right to have trial. The amount that's owed is owed. We can talk about the amount owed at a later juncture. I'm still willing to work with you as far as paying. The number one thing is getting yourself in compliance so that we don't have, if we keep having additional tickets, there's no incentive for me to offer any type of financial relief to you. Because the number one thing, you've heard me say this to people who come in. First question I have is, are you getting any more of these tickets? When did you get the last ticket? Because I want people in compliance. Once I understand that they're in compliance, then I can start working with how much financial burden they have to bear. But right now, if tickets are still getting issued, and if I go back, the most recent ticket that was issued was earlier this week, December 2nd.
Yeah.
So if tickets are still getting issued, it's probably not a good time to resolve financial burden. That's what I do on those Friday sessions. I have people come in and they say, yeah, I got these 4 tickets for parking in front of my house. I didn't have a permit for my neighborhood. They show me the new permit. I give them some relief, and I don't feel like I'm disregarding the law in that way of what people are trying to do from an enforcement perspective. Same would be the case with you. Once I see that there's compliance and there aren't a lot of tickets issued, then we can start worrying about how much you owe. But we also have to deal with the tickets that are ones that you have trials. And that's where I'm going to start, is we're going to have trials first.
Yes, Your Honor. But if I may,
There
I,
won't
of
be
course,
compliance
have,
until there's consequences.
comply
Good.
with
It's up.
the court, and I thank the court for the generosity because, as you recall, I actually did pay a fine for the one that was towed impound and towed, and I did appear in court when Your Honor invited me to discuss the outstanding amount,
Right.
and I have true proof to show that I'm working towards that.
Good.
But of course, and have accomplished quite a bit of that. But even more importantly, Your Honor, you would have seen that the number of tickets issued, the vehicles that has been issued tickets, the actual quantity and number has dwindled. So now we're no longer talking about the 5, 7.
I've noticed
vehicles.
you had a couple on November 21st, and then there was an 11-day difference, and you didn't have one until December 2nd. That is an improvement. Okay, so
Whatever it is, I thank you, Your Honor.
okay, but let's cross where we are right now. What I would like to do, Mr. Reynolds and
Good
Mr.
job,
Lau,
Lau.
is
Getting less tickets.
I'm going to do a written order on these 4 cases so that it's clear about my interpretation of 7624B. And then I would like to, I can schedule a short 30-minute settings hearing to set trials. That might be the best so that you all can have some communication. And if you have agreements, great. It might be 5 minutes. But if there are disagreements, I can resolve them then and say, we're going to do these trials. I think 4 is about, maybe we do 5, depending what they are. If it's a slew of license plate violations, we can do 10 of those and probably crank right through them. And it may be that you all can work out some agreements on those. But I want to give you a chance to work with the enforcement folks, figure out how you want to group them, Mr. Reynolds, and give them, you can have a conversation by email or by phone with Mr. Lau. But let's go ahead and schedule a settings hearing. Does that make sense, Mr. Reynolds?
It does make sense, but I would be open discussing with Mr. Lau a way to kind of like clean the slate, so to speak, for the open tickets that he has, because he might have more in the future. It sounds like he's getting fewer, but I think it is kind of almost it's hard for anybody to wrap their hands around as many tickets as he has, and he has limited financial resources. So if there's a way that we can resolve the outstanding tickets without having a bunch of trials, that would be my preference. So I'm happy to talk to Mr. Lau about what our recommendation might be to the court for what the financial penalty would be for his outstanding tickets, so that we can take care of them via reduced financial penalty rather than having a bunch of trials and then the financial penalty just being whatever was on the tickets themselves.
So let's do this.
So Your Honor,
Yeah.
I need clarification. I don't understand the terminology of open tickets. Does that mean, because Your Honor, thanks to the court, you have already looked up that at one point, this would be now back in October, it was $2,500 and change that it was supposedly owing.
Are we going to have giving him a printout?
There's a complete
Yeah.
printout of every.
Can you give one of those to Mr. Reynolds as well?
Yes, okay. So, wow, double side. Thank you. So,
Is that in order with the issued versus warnings?
So-
or not?
Their descending order from most recent to.
no, that already helped me.
Newest to
tremendous.
oldest, and then sorted also by issued.
Okay.
So they
And 4 of those are still the ones that I've already resolved today, right?
yeah, I
4 of those that are listed.
haven't corrected those in.
So those are still, even though you see them, what he's given to you is a list of the ones that have been issued and in order there. And he's going to give the same to Mr. Reynolds. And that'll give you all a chance to kind of work through the system, figure out how you want to go about it. It also shows the balance. And what Mr. Reynolds is describing is maybe between the two of you, with parking services playing a role in the discussion, finding a way that, number one, they can get you to compliance, right? When you think about what the city's goal here is these folks who are issuing these tickets, they're being told to go out and issue the tickets because it's a burden on the community to have the city streets with vehicle violations occurring every single day. And so they're going about that. So they've got a goal, right?
Your Honor, I have never questioned the social aspect of this, as you may recall from my various appearance. I am just wanting clarification, the open tickets, does that, and I've already phrased it, but obviously poorly. Back in October, Your Honor, you have already helped tally up that is $2,500.
It's much more now.
Yes. So I would eyeball it, likely based on late fees and whatever, it will be 5,000-6,000, give or take.
There's an amount at the bottom of that thing, I think.
Oh, sorry. No, there is no
So
late
there is,
fee.
yeah, on the very back, page, Mr. Lau.
No, wouldn't that be a late fee? No, this is not because
What I was
late fee
looking
does
at,
not pop up
Do you want the printout?
at least earlier
I was looking at.
until T2 and stuff like that. So this is not indicative.
All right, well, I will just tell you that the screen that I was looking at shows a total balance of 35,33.75.
So what does send to collection means, Your Honor?
It means once a ticket has gone through, it's become in default and someone hasn't paid it, we have the legal authority under the ordinance to send it to a collection agency, and then they can pursue recovery on behalf of the court.
Okay, so, and the fact that because these are July and June of this year, I'm looking at page 2 based on Greg's printout. I just noticed those new terminology. So I should have received some notification.
Where are you talking about on page 2?
Sorry, Your Honor. The second
Oh, I see
page,
where it says there's a few that were sent to collections, yes.
roughly lower half.
Mhm. Right.
The 3 back to back.
Yeah.
And then the 3 after that, void approved,
Mhm.
which I have no clue what the void
Just means
means.
it was voided, the ticket was voided, and it was.
By parking, not by
Yes.
me.
That's right.
Okay.
They voided the ticket.
Sent to, yeah, so we may have to, so maybe,
Let's worry about one thing at a time for today, okay? And I'll take up other questions with you on a later date, but it's 4:30 and I do want to wrap up our hearing today because Greg's got to go help his staff get balanced and cleared out of here. What I would like to do is schedule this for a setting hearing. I can set it far enough off if you want to have some follow-up conversations with Leo and staff at Parking Services, Mr. Reynolds, Fred and others, however you want to do that. I'll leave it to you, but if we could schedule this off for a settings hearing, I'm open to whatever. Keep in mind my role, I'm independent between you and the prosecution. So if you and the prosecutor work out some kind of agreement on how to resolve your parking matters entirely, then I'm going to accept that. All right, that's an issue that enforcement has the ear of prosecution. They can tell him what they think is appropriate. You can represent yourself. And if you all work out something as far as how you want to resolve trials, how you want to resolve payment obligations, I'm an open ear to that. But I want to give you all an opportunity to do that. Whether you can do it or not is a totally different question. But I want to be able to keep the cases moving forward if you can't do it. Okay. And that's why I want to have a settings hearing in the next couple of weeks. So Greg, if you can just look in full court and see what we have available. It can be any time really. It's just going to be a 30-minute
yes.
deal.
Yes, Your Honor, I definitely would like to think that one can work out something, but the enforcement has always been heavy-handed and one-sided, my comment.
That's your view.
However, because of health and caregiving issues, and because of also the code enforcement issue as well, I am actually way less available until after January 8th, because that was because of code enforcement, but even this month is because of health and caregiving reasons. And if we are to tentatively schedule some court date,
Then we should.
I would welcome
If we're going off to January, I'm going to schedule
Yes.
an actual trial date then.
yes,
We would just have a trial date scheduled because that's far enough off that I don't want to be in a position where we're just then scheduling trials.
yeah, because, yes, that is why I offered that time frame because that would allow us to,
Mr. Reynolds, what I'm hearing from the defendant, he doesn't want to schedule any more trials until January. I want to hear what your position is on that.
Well,
Because I do still have some trial slots available in the month of December.
I would prefer, I don't think that we can have a trial setting that will resolve all of his eligible open tickets that can be set for a trial, because I think as the court said, there's like 21 of them. And so that would require probably at least 5 different trial settings. I would still like to try to come to some sort of a reasonable financial resolution with these open tickets so that we can avoid having 20 parking ticket trials that will, from the city's perspective, likely put Mr. Lau in a worse financial position than if we don't have the trials and come to some sort of an agreement.
Your Honor, I actually
Let him
appreciate that,
let him-
welcome that.
Let him finish
just-
so I can finish
okay.
this thought with
I
him.
actually welcome that.
So I would, I think that I know that Mr. Lau is saying he's unavailable for the rest of this month, but there's got to be like a 30-minute time slot that he could talk about.
Yeah.
When he's available for potential trials.
Yes.
And I would like to also engage him in the when the court's not in the room together to talk about how we can just try to resolve this.
All right, so to say today is December 6th, I want to schedule a settings hearing for the week of December 16th, which is 10 days from now. And Greg, we're going to have to force that in, but we could do it on the 17th is a Tuesday. Let me just double check what I've got. And
Please do.
December 17th, we could do something at 3 p.m. or later.
So, sorry, Your Honor, and based on what, so the half an hour is
It'll
to
just to pick out with
with you.
me here,
And us
Mr. Reynolds,
trying to,
figure out what cases are going to trial.
Okay.
Or if there's a resolution, great.
my apology, I did not convey myself once again adequately nor properly earlier. I meant, of course, to say that I'm very available for trial starting mid-January, and even at the 4 or 10 tickets that Your Honor has suggested earlier, I'm perfectly open to, but that would at least allow us a set time frame. I'm perfectly open to any discussion with Mr. Reynolds by email or whatever.
I want to have a date.
Prior to-
I'm going to have I'm going to give you, we're going to have a settings hearing sometime that week. So it will be December 17th, or it'll be another date that week. I could do the 17th anytime at 3 o'clock or 3:30, 4 o'clock, any of those.
3 o'clock that day works.
3 o'clock. Mr. Lau,
I have to check on when.
it's Tuesday, December 17th.
I'll let you guys know.
And Your Honor, I'm going to use today's case for that. since
That's
I don't have
fine.
cases
Yes, yeah, I think that makes sense. That we won't know which parking cases go to trial. We'll
So
just, it'll be a review hearing, right? We'll just call it a review hearing, but it'll really be a settings hearing for the next trial.
So it'll be still be 5655 then?
Yep, this case for
Okay,
right now.
yeah.
3 o'clock?
December 17th, 3 p.m. is fine.
Perfect.
So.
You all are free to have any conversation you want without me.
That's great. And so it sounds like we have the next court date set. And so
Well, we have a very brief court date
right.
set to
So I
discuss.
can talk to you right now, Mr. Lau, if you're available. About what we
Okay,
can
so if I may just,
Greg's gonna print out a setting
Yeah.
notice.
I'm
for you.
also going to email it, lowdesigns@gmail.
Yes.
Okay, so I'll
Great.
email it to you as
Yeah.
well.
Can you please email this to me as well, the list, please? Because I don't have an OCR scanner that can, so I have to physically hand type each and everything.
Yeah, we don't care.
So.
Okay,
if I
so
may-
yeah, that'll get emailed to you, but likely
Thank you.
until
Yes.
Monday.
Did you hear him say- It'll be Monday.
Thank you, that would be fine. Um,
Okay,
Thank you, Your Honor.
you're welcome. Okay, and in the meantime, I'll do an order on these cases. And I encourage you guys, if you can find a way to resolve this, Mr. Lau, I know the property. I've seen dozens of pictures. You got to find a way to get that property in compliance, get your situation in control with the vehicles, and then we can figure out the money thing, okay? The enforcement, the fines are designed to get people into compliance. And so if you can get yourself into compliance, then everything else will fall from there.
Your Honor, only because you brought up the code compliance thing again. The prosecutor side, of course, I'm not the defendant in that case, but has asked for a whatever trial to void the court decision.
Yeah, we'll see you on another date for that.
20th.
Yep,
And
I know,
so there's no shortage of things for me to do, Your Honor.
I know. They will go away as soon as you get the property rolling, get it in compliance.
And I'm not even an owner there.
I know you're not. It's problematic.
So.
Greg, thank you so much for
Irony.
your patience. Mr. Reynolds, thank you for.
Always make me smile. Of course, thank you, thank you.
And I'll get a copy of that for you.
And yeah, please also email, please. It's tough enough for me to find photos. Thank you, Your Honor.
You're welcome. Take care.
Okay, Mr. Reynolds.
Yeah, Mr. Lau.
Greg, when you see me before you leave, I just want to check in with you about something.
Yeah.
Oh, good Lord. There you have it. That was kind of wild. I have to say, I didn't expect him to get a win, but he did. He got a W today. He talked the prosecutor into dismissing one, which makes sense. By the way, that's not a big deal. It is kind of a vague statute. The judge gave it a reasonable interpretation and found in his favor. Basically, because they're sloppy in the way that they document how he's there. They need to tighten that up. They need to figure out whatever the hell will make the judge happy. Like, seriously, we had it in the comments. I was thinking the same thing. What do you want? You want them to stake it out and sit there and look at it for 48 hours? Probably not. Probably just a good photo of the beginning and the end will get it done. But who cares? He still lost 4 out of 5. And he's going to lose a lot more. And he's in violation every day. They could go out there and write him 12 more tickets tomorrow. So none of that's a big deal. None of that's a big deal. But I'm learning more stuff. I haven't watched. There's Alyssa. It's her fault. Blame her. The next one's short. We got that going for us. And apparently there's some crazy stuff coming down the road, but I will not watch them ahead of time. I need to watch this unfold live from my perspective. Good times. Thanks for coming out. I'm not bailing you out. It's too late though. You guys are going to behave no. Yeah. I mean, I doubt anybody's watching this at the bar. All right. I'll see y'all soon.